and I'd like to reserve 5 minutes for rebuttal.
All right. May I proceed?
Thank you. May it please the court, Patty Whitehead of Reuben Loveland, appearing on behalf of Appellant Newrez, LLC. This case concerns the treatment of how first priority liens on real property are treated in insolvent estates when they're sold by order of the court. In this case, Newrez was the holder of a VA-backed loan on the decedent's property in Montgomery County, Tennessee. This deed of trust was executed by Mr. Wallace, the decedent. During his lifetime, it was properly registered in the court. There is no dispute that Newrez had a first priority lien on the property. However, despite this lien, the court in its order dispersing the funds said that Newrez should only be paid approximately 70% of what was due under the loan when the property was sold. This isn't a case where the property was sold for less than the amount of debt. There was equity in this property of about $9,000 after the special commissioner's fees were paid, and if Newrez had been paid in full, the estate would have gotten $9,000 to distribute. But that is not what happened here. Since the estate had incurred upwards of $45,000 in attorney's fees and other expenses, the trial court essentially created a judicial super lien for the estate, which was paid ahead of the mortgage debt. And the basis for the trial court of this decision was Tennessee Code Annotated 32317, which is what we're here before the court today. This statute provides a scheme for distribution on claims and demands of insolvent estates. So we would submit to the court that the trial court made two errors in its order to only pay 70% of the debt due under the mortgage to Newrez. First, the court erred by not failing to pay off the loan directly from the proceeds at the time of the sale. Second, we believe that the court erred in its application of Tennessee Code 32317 in holding that the deed of trust was subject to this insolvency statute. A quick rundown of the facts of this case. The mortgage was taken out by the decedent in 2015. He died in 2018 without a will, so his property passed directly to his heirs at the time of death. And this property was in Montgomery County. He resided in Dyer County at the time. An estate was opened in 2019. The estate had petitioned the court to approve a private sale. According to the record, the sale didn't go through because the buyer couldn't obtain financing. A year later, in 2020, there was a petition for a public auction of the property. Newrez consented to this. It's within the court's authority to order the sale of property in insolvent estates. At the auction, it was sold for $167,000. This was higher than the private sale from 2019, which didn't go through. And the debt to Newrez at that time was $151,000 approximately. The special commissioner in his report that's of record with this court directed payment directly to Newrez of the funds. He then said the remaining funds of approximately $9,000 would then be put in the registry for distribution. However, the court amended the special commissioner's report and placed all of the proceeds other than the cost to the commissioner and cost of the sale into the registry of the court. While Newrez didn't have notice of this amendment prior to it being entered, it's our opinion that our first priority lien attached directly to those proceeds. So we were still entitled to the full amount of proceeds, even with the court. Later, a notice of insolvency was filed. We objected to the notice of insolvency, which was trying to disperse pro rata instead of payment in full to Newrez. And we held a hearing over this, and in that hearing, the trial court ordered we were only due 70% of the balance and said that the statute applied. So the $45,000 of attorney's fees, the cost of the administrator, cost of the estate, were all to be paid prior to the mortgage. This was the wrong decision, and this court must overturn that order and direct that the mortgage be paid in full.
Are the funds being held by the court?
Yes, the funds are still with the registry at
Okay,
this time.
all right.
So this interpretation that we are putting forth to the court is proper under not only Title 66 of Tennessee Code Annotated, but also Title 30, which deals with estates and insolvency. As the court's aware, this is a race notice state. There's no dispute that we had a first priority lien on the property. And in order to properly convey title, you have to clear the title of all the liens. You can only convey what you have. If I have an encumbered estate, I can only convey an encumbered estate. At the time of the sale, the estate only held an encumbered estate. This does not provide any conflict with Title 30 of the insolvency statute, which does provide for how funds are to be dispersed. We all understand insolvent estates, some people will not get paid. But we would submit to the court that the deed of trust and the mortgage in this case isn't subject to that statute. That statute begins with, it applies to claims or demands on the estate. A deed of trust isn't a claim or demand on the estate. It is attached to real property. This is why in any probate case, a mortgage doesn't have to file a claim of the estate to be paid. It's attached to the real property. It's there. The real property isn't even brought in unless the court orders it. And so therefore, the deed of trust isn't a claim or demand. It's also not subject to the 1-year bar for not filing a claim. The deed of trust is secured by the land. This is also supported by Supreme Court cases dating back to the 1800s. Even though these cases are very old, they are still binding. In Fields v. Wheatley from the Tennessee Supreme Court in 1853, it states, statutes regulating the administration of insolvent estates were not intended and cannot be construed to affect in the remotest degree liens acquired in the lifetime of the deceased insolvent. In 1859, the Supreme Court in Wintage v. Elredge held again that there's a legal advantage to having liens on property. It is a distinct and independent right. It is only what remains after the discharge of the encumbrance that would go into the fund for distribution. And that is what we propose the court should have done in this case. As the special commissioner had written in his report, you pay the lien, the estate only has interest in the equity, which was about $9,000. Then this insolvency distribution statute would be applied.
What findings did the court make to disregard the report of the special commissioner, if any?
So they weren't in the order, but in the transcript that is provided with the court, the estate had made some comments that Newrez had specifically delayed the sale of the property in order to increase its amount of debt. None of those, that's not supported by the record in any way. At the time of the private sale, the debt was $131,000. By 2020, that debt had increased to $151 approximately. And that was due to Newrez's upkeep of the property, paying taxes. No payments had been made, so things had gone up. But the trial court did reference that given the history of this case, if we had approved the sale in 2019, we would have been paid in full of approximately $131,000.
131 or 151, which is it?
131 in 2019. The price did go up by the time of the sale due to taxes, upkeep, other property maintenance, and no payments being made on the loan at that time. But
Did the court make findings as to specifically what delay, or you said the court stated in the transcript that delay had occurred on the part of Newrez. Did it make findings as to what that consisted of?
it did not. It merely stated based on the history and said if you would have closed in 2019, you would have been paid in full. Newrez didn't have any authority to close at that time. You don't have to have approval to sell your own property from the mortgage holder. The mortgage holder simply has to be paid in full. And according to the record, the buyer didn't obtain financing at that time. There's nothing in the record stating that Newrez was specifically trying to delay the sale in any way. There's no findings of fact in that. There's just the argument of the state council that we did in order to create more debt and to rack up our fees. But Newrez was expending money to upkeep this property.
Let me ask you, in the order in this matter, paragraph 8, the court says, after the close of the proof, the court is of the opinion that the total amount due and owing Newrez is $156,278.43. Did you appeal that determination?
We did not appeal the 156, so at the time, due to COVID, the objection hearing was actually a few months later, and that amount had gone up, so we had submitted a new payoff statement at the hearing, and the estate had also submitted additional attorney's fees. And so the amount due to pay off the loan that we were seeking at the objection hearing was $156,278, but the court only issued about $106,000 in
And
payment
so
to us.
that determination has not been appealed, the 156,278.43?
No, that has not been appealed. That is
Okay.
the amount that we're seeking.
Okay, all right.
Thank you. We hear from the appellee.
Afternoon, Your Honors. Richard Shepke with the Dyer County Bar. Pleasure to be here. If it pleases the court, as has already been stated, the real issue here is regarding the division of funds and the allocation of proceeds of sale in an insolvent estate. This estate was declared insolvent back in 2019. The property was then liquidated. Again, it took a few tries to get there, but the property was ultimately liquidated by order of the court, and then those proceeds were held by the, and still are held by the clerk and master to be distributed in accordance with 32317 as brought in through 35501, the insolvency statute. So basically what happened here is Mr. Wallace owns the property in Montgomery because he was a veteran when he got out of the service. He worked for the Dyer County Sheriffs. He was killed in a car accident, leaving 2 minor children, which made it very difficult to, nobody can consent to anything. We've got a bunch of minor kids. We were working on liquidating the property with the expectation of obtaining approximately $20,000 of equity out of it for the children. And then in our talks with Newrez, they ultimately decided to begin foreclosure proceedings instead of allowing the property to be sold. When they did that, the largest part of the increase from 135 to the 151 is actually due to their foreclosure mechanisms that they began to engage in. They went and appraised the property. They did several other things that are set forth in their breakdown summary that's in the record, but that's the lion's share of the balloon from 135 to 151, which again is eating up the vast majority of the equity that we expected to realize out of the home. And in fact, by so doing that and beginning foreclosure proceedings, the estate was then effectively rendered insolvent. We had other claims, we had other obligations, and so
Let me ask you
Yes,
a
ma'am.
question. So are you saying that but for the property potentially being foreclosed on, your estate would have been solvent? If you had gotten $20,000 out of the sale of the property, which I think is what you said you expected to get,
Yes,
around
ma'am.
20 clear, that would have paid off all the debts and you'd have been solvent?
Yes, ma'am. That was this was the end of 2018, early 2019, but that is correct. At that point in time, we were still right side up on being able to close out Mr. Wallace's financial affairs. He was 37 years old, so he has credit cards, he had things. He wasn't like my elderly clients who have savings. He was 37.
So you're saying if you had gotten 20,000-ish at that time, it would have paid all the debts and the cost of the estate administration and everything?
And we would have had some funds left over for the children. That is correct, Your Honor.
Was it in default?
The mortgage
Yeah.
in 2019, yes, sir. The children are not employed. They did not have any funds with which, and Mr. Wallace he was a deputy sheriff. So there was no monies laying around with which to service the mortgage. So it was in default after his death.
So you're not,
Go ahead.
so you're not arguing that the foreclosure was in some way wrongful or in violation of the rights of the lien holder, or of the debtor, excuse me?
Under the terms of his mortgage, I believe that they are where he borrowed the money. I think that they can opt to foreclose on demand. I'm assuming that. I haven't actually read their paperwork to see how they choose to word their things.
I think what we're alluding to is
Right.
there was nothing, you sort of made it sound like they were doing something improper, I think.
Oh, no.
So-
Meaning, now, it was simply an undiscussed change in course, which is to say, back in 2018, the lender and the estate had agreed to list the property for sale. Unannounced or not disclosed to the estate, the lender then undertakes foreclosure proceedings. And their foreclosure actions, the unilateral taking of the property at the expense of the estate that made it impossible for the estate to service its other obligations, which is what Your Honor had alluded to, which is if we had our ability to liquidate the property and realize the proceeds was necessary for the estate to be funded. Now, since that time, since the estate became insolvent, we had to liquidate the property for the purpose of allocating that debt, or I'm sorry, allocating the proceeds of sale amongst our different creditors in the estate. And so that was what we did. When the estate was now insolvent, the court stopped the foreclosure sale so that the property could be liquidated subject to the court's jurisdiction because the estate was in fact insolvent. And when that happened, so the property is then sold and the proceeds are then held by the clerk and master so that they can be allocated in accordance with the statute so that we can give all creditors notice. The reason why the funds can't just be distributed immediately as was suggested should happen is because there isn't enough money to go around. And so we can't just unilaterally distribute funds without giving all of the creditors due notice of their opportunity to object to what they're going to be getting.
How is their priority over the mortgage, I think, is what we're trying to figure out. How does the estate have priority?
Oh, that's set forth in the statute itself. The statute of 32317 sets forth the priority expenses and in what order debts get paid when there's not enough to go around. And that includes in subparagraph C the reference to promissory notes, which is the underlying obligation on the real estate between Mr. Wallace and Newrez. So all the reason why is because there's no effective means for concluding the decedent's business affairs if there isn't some mechanism for allocating those funds, allocating what's going on in an insolvent estate. The statute, the Tennessee legislature said that this is how we allocate the funds.
Well, this wasn't a suit on a promissory note, was it? This was a deed of trust.
Correct.
That's not the same thing as a promissory note, is it? This was a secured interest in real property.
Yes, Your Honor, it is.
So
Subject to the
how was
jurisdiction
their
of the Dyer County
How was
Probate
their
Court.
priority? How did the estate get its priority ahead of the mortgage?
The estate is not claiming priority ahead of, if Your Honor is like, there's no funds being distributed to the beneficiaries in this estate. So we have not reordered the priority with which people are being paid. All that we have done is allocated the funds in accordance with the statute, what the Tennessee legislature said to do. The Tennessee legislature said to allocate these funds in this order, which is what we did.
Which would be fine if you didn't have a secured creditor.
Correct. Now, we didn't move it, nobody has moved ahead of the secured creditor, as set forth in the statute per the Tennessee legislature.
But you're making your secured creditor take a pro rata share of what's owed to them and classifying them in with your other creditors in
No,
an
ma'am.
insolvent estate.
No, ma'am, we have not.
So you're paying them in full?
No, ma'am, but we are not putting them in with the general creditors. The cases that have been cited to are discussing just that, which are, these cases from the 1800s are discussing whether the secured creditor has to be lumped in with general creditors. In this estate, as set forth in the notice of insolvency, no general creditor is being paid in conjunction with the secured creditor. We have two secured creditors. There's the truck lender and the home lender, and both the truck and the home lender are being paid in accordance with their security interests. No general unsecured creditor and no beneficiary is receiving anything out of this estate as a distribution from the estate. And the general unsecured creditors, we had 4 or 5, they've received nothing.
So are you proposing to pay Newrez $156,000?
There's not enough money with which to do that, Your Honor. Not once because in accordance with the Tennessee legislature and the statute for insolvent estates, we're required to pay certain expenses first, like the court costs.
The attorney's fees paid in full?
What's that?
Were the attorney's fees paid in full?
I believe, yes, Your Honor, as in the allocation down of the statutory hierarchy. The court expenses, the reasonable personal representative and attorney's fees, then it's the funeral expenses, and then we're getting down to subparagraph C in those category of creditors in which both Newrez and Bridgecrest, the truck lender, hold security interests in their underlying collateral, which is why they receive all of those funds. The funds, once we get to that category, are not going to general unsecured creditors.
Looks like you're proposing to pay Newrez $106,000, a little over.
I believe that's correct, Your Honor, pursuant to the probate court's order, which is the allocation of those funds in accordance with their interests in their underlying collateral once we get to that category. So what the probate court did was it allowed Newrez to amend the amount that it was owed from 151 to 156. It updated the attorney's fees. And again, the bulk of those attorney's fees were all incurred in conjunction with everything from 2019 on is trying to get the property liquidated. We went to federal court, we came back, we had to, because the federal court said that it was the state court that decided what was going to happen with the real estate. Newrez has had no objection to the jurisdiction of the probate court to liquidate the real estate, and that's because the court does have the authority to do so, and that authority includes this authority to allocate the funds when we're insolvent. And that's what we've done here. Those funds were allocated in accordance with the statute, and again, we have not moved anybody's priority out of sync with what the statute requires.
And you don't dispute the 156 amount, is that correct?
Correct, Your Honor. That's what the probate court ordered, and we have not appealed that.
Okay.
So the other items I guess I wanted to point out to Your Honors is that all hearings that took place in the probate court occurred with notice to all parties, which included Newrez. So everybody was privy and provided the opportunity to participate, whether they chose to do so or not. There were no clandestine hearings. The court made its findings at each one. Those are reflected in the court's orders. And again, the liquidation of this property and the subjection of the proceeds therefrom to the jurisdiction of the court and the allocation in accordance with statute, all of that occurred by consent. All of that was done with the consent of the appellant before Your Honors. And so what we're having to decide, or what they've appealed, is whether or not the court is to apply the insolvent estate statute in allocating funds. And it has to happen that way, because if we don't, then there's no guarantee that there will be enough money to be able to conclude a decedent's affairs.
But who's to say? And if you
Yes.
follow that line of reasoning,
Yep.
so you're saying that anytime someone dies and they have bills that have to be paid, that the mortgage is automatically going to have to be adjusted, basically. And I know that's going through the procedure here that the
Right.
court went through, but basically that if you die with other bills and you have a mortgage on your real property, that the mortgage holder doesn't get paid because they've got to essentially make room for those other.
We'd have to categorize what those other bills that Your Honor are discussing. If they're unsecured creditors, oftentimes when there's a deficiency, they're the last ones that would have ever gotten paid. Actually, it's the beneficiaries who get nothing first. Then it's the unsecured creditors who get nothing next. And then we're talking about undersecured or partially secured creditors, and then you'd be talking about fully secured creditors when you're allocating the funds. Point being is that in this instance, Your Honor, the beneficiaries got nothing, the unsecured creditors got nothing, and then we were looking at the funds that remained, and those are subject to the priority security interest of the mortgage holder in this instance. So they did get all of that money once we got, we didn't rejigger anybody. There was no credit card that's an unsecured creditor claim or anybody who's unsecured who then said, oh, well, you get a piece of the mortgage company's money. The mortgage company is protected with respect to their collateral at their category.
So then who got a piece of the mortgage company's money?
Those funds were allocated to,
Attorney's fees.
Attorney fees.
that's right, we have attorney's fees, there's a personal representative fee, there are fees for, and then it's the allocation of funds to Newrez and to Bridgecrest. That's correct, Your Honor. And again, Your Honor, we those fees are incurred through the actions of Newrez going to federal court and back and attempting to liquidate the property. That's where those fees came from. Again, if the property had been liquidated at the beginning, they would have been paid in full because the estate wasn't insolvent. When their actions rendered the estate insolvent,
If the foreclosure had gone forward, if y'all hadn't stopped the foreclosure, then there wouldn't have been, then those fees wouldn't have been incurred either.
that's correct, that's right. They would have taken the minor children's equity and walked away with it. Correct, Your Honor.
They didn't get any equity anyway.
Not now. They would have then. Thank you.
Thank you. You have your rebuttal.
And I would like to just make a couple of points concerning what Mr. Shepke had brought forth. First, I would like to say, if we look at the order, it does disperse approximately $47,000 of attorney's fees to Mr. Shepke's firm in this case. The actual cost to the one-year support and the administrator are under $9,000 in this case. So the majority of the expenses here did go to the attorney's fees. The estate counsel's representations that Newrez caused them to incur the fees, it's incorrect. We did move forward with a foreclosure because that is our right to do as a secured mortgage on property. Now, there may have been conversations previously because the decedent in this case died in August 2018. We started proceeding with foreclosure in January 2019. Under federal law, there's a certain amount of time that you have to wait before you can foreclose. You can't foreclose if someone is 1 day late on your mortgage. Generally, you have to wait 120 days, and there are steps that take for foreclosures to actually occur. Now, when the estate received notice of the foreclosure, they did file an action against us to stop it, along with some other claims. They never served Newrez on that. They served Reuben Loveland, my firm, who acted as substitute trustee in that case. I would like to note that the estate didn't appear in the federal court. They didn't appear, so I'm not sure what fees would have been caused by that. Any other fees causing the liquidation of the account, Newrez is allowed to object to what the court wanted to pay them. We're allowed to do that within our rights. We're allowed to participate in good faith. We consented to the property being sold by the court. We consented to the special commissioner's report paying us in full at the time. We objected when the estate said that we shouldn't be paid in full. And if this court were to allow this decision to stand, it essentially creates a judicial super lien against real property in favor of the estates. Maybe not the unsecured creditors, but the attorney's fees, the estate administrators, other costs are all being allocated prior to the mortgage. In this case, over $50,000 was allocated ahead of the mortgage, which we were due. If this is going to be the state of the law, it's a better practice for a bank to foreclose on a terminally ill borrower rather than risking its loss of a first priority lien on a mortgage by waiting until after they pass to foreclose or to seek repayment.
There've been some statements made about the propriety of the foreclosure or attempted foreclosure. At any time, did the mortgage company enter into any sort of an agreement with the estate that they would basically forbear and not foreclose for a certain amount of time? Was there some type of agreement to that effect, or was it just?
There's nothing reflected in the record
All right.
that there was any agreement. And in fact, Newrez actually didn't even appear in this case until 2020 with a petition to sell the real property. At the earlier petition, only Reuben Loveland was served with that, not Newrez. So in closing, I would just like to say the facts and the application of the law in this case are clear. First priority secured liens on real property have distinct and independent rights away from insolvent estates. As the Supreme Court said, neither death, nor statute, nor insolvency can disturb the right of a secured lien on property. This has been the state of the law for over 170 years. It is the practice that it be paid. The special commissioner, who is the clerk of court in Montgomery County, in his report said we should be paid. But the court, in its reasoning and all that we know by the transcript, is based on the history and possible actions of Newrez, which isn't supported by the record. They said, we're going to give you 70% because we have to pay attorney's fees ahead of that. So therefore, we are asking the court to reverse the trial court's decision in this case and to pay us in full the $156 that we requested at the time of the objection hearing. And we would also ask that this court hold that secured liens on property are not subject to Tennessee Code Annotated 30-317. If they were subject to this, it is creating a judicial super lien for insolvent estates, which would chill the mortgage industry in full, and this order cannot stand.
Thank you very much. Thank you, counsel. We'll take this under advisement and issue our opinion as soon as possible. Madam Clerk, you may adjourn court for the day.
All rise.